filling vacuums in the law. This is something I brought up with her. That concept greatly worries me because courts should never fill voids in the law left by Congress. Judge Souter's decision on the Supreme Court, I believe, demonstrates that he does believe courts do indeed fill vacuums in the law, and in the only case of voting for a Supreme Court judge, either by a Republican or Democrat, I've regretted my vote to confirm him ever since. So I've asked several Supreme Court nominees about courts filling vacuums at their hearings. Judge Sotomayor's lukewarm answer left me with the same pit in my stomach that I've had with Justice Souter's rulings that I had hoped to have cured with his retirement. And it reinforces my concerns with her hearing testimony, cases, and speeches. In conclusion, all judges must have a healthy respect for constitutional separation of powers and judicial restraint. All judges must be bound by the words of the Constitution and the legal precedent. However, Supreme Court judges are in a very special position with respect to their decision-making process. The Supreme Court has the final say on the law. Justices on the Supreme Court have fewer constraints on their judging than judges on the district or appellate court. So it's critical that we ensure nominees to the Supreme Court will resist the temptation to mold the Constitution to personal beliefs. As one witness testified at the hearing, the judicial restraint of the Supreme Court justice is self-restraint. She's a remarkable woman. She's a talented individual, woman of substance and personality, a trailblazer. There's no doubt of her intelligence, integrity, or distinguished legal background. We're proud of those accomplishments. However, I don't believe that the judges possesses a critical ingredient of Supreme Court justices. Unfortunately, I'm not convinced that Judge Sotomayor will be able to set aside her personal biases and prejudices and decide cases in an impartial manner based upon the Constitution. I'm not convinced that Judge Sotomayor will protect important constitutional rights, and nor am I convinced that she will refrain from creating new rights under the Constitution. I'm not convinced that Judge Sotomayor understands the proper role of a judge in our system of checks and balances. Only time will tell which Judge Sotomayor will sit on the Supreme Court. Is it the judge who proclaims that the Court of Appeals is where policy is made? Is it the judge, or is it the nominee who pledged fidelity to the law? Is it the judge who disagreed with Justice O'Connor's statement that a wise woman and wise man will ultimately reach the same decision? Or is it the nominee who rejected President Obama's empathy standard? Only time will tell, and I hope that I'm wrong on this vote, but I think based upon what I saw Judge Souter do and where she's coming from, I think I'm right by voting no.
Hey, Mr. Chairman, I'll be brief, but I do want to say a few words about Judge Sotomayor and about the hearing process we've just been through. First, I want to commend you and your staff for a remarkably well-run proceeding. I think that anyone who saw the 4 days of hearings would agree that the process was scrupulously fair. Everyone got a chance to ask all the questions they wanted to ask. They had the time they needed for follow-up questions and for follow-ups to those follow-ups, and no stone was left unturned, even if the answers the judge gave weren't always what the questioner hoped to hear. What the public doesn't see is the work that is done behind the scenes to get us to that point, not just the setup of the room and all the complex preparations that go into the smooth running of the hearing itself, but also the enormous effort to make all the background information that came to the committee available online virtually immediately, all of Judge Sotomayor's speeches and articles, over 100 letters and reports from people who know her or organizations that wish to express their views on her nomination, as well as all the materials received from the Pearl Deaf organization in response to the committee's requests. So, Mr. Chairman, I think you've set a new standard for transparency and public access to Supreme Court nomination proceedings, and I truly want to commend you for that, and thank you for all you and your staff have done. It's been tremendous work. The scrutiny to be applied to a president's nominee to the Supreme Court is the highest of any nomination. The Supreme Court, alone among our courts, has the power to revisit and reverse its precedents, and so I believe that anyone who sits on that court must not have a preset agenda to reverse precedents with which he or she disagrees, and must recognize and appreciate the awesome power and responsibility of the court to do justice when other branches of government infringe on or ignore the freedoms and rights of our citizens. And that is the same standard I applied to the nominations of both Chief Justice Roberts and Justice Alito. What we saw over 4 days of hearings on the nomination of Judge Sotomayor was a thoughtful, intelligent, and careful judge, a person committed to her craft and to the law, someone whose remarkable life story and varied experience will add diversity and perspective, which the court sorely needs. Not only will Judge Sotomayor become the first Latina justice and only the third woman to serve on the court, but she will be the only justice who has served as a trial court judge, and she will have more judicial experience at the outset of her service on the court than any of her colleagues did. There is no doubt she is highly qualified, and I think we saw during those 4 days of hearings that she has an admirable judicial temperament and demeanor that will serve her well in the court. Judge Sotomayor's record and testimony satisfied me that she understands the important role of the court in protecting civil liberties, even in a time of war. She sat on a Second Circuit panel that struck down portions of the National Security Letter statute that was so dramatically expanded by the Patriot Act. And when I asked her how September 11th changed her view of the law, she gave the following answer. The Constitution is a timeless document. It was intended to guide us through decades, generation after generation, to everything that would develop in our country. It has protected us as a nation. It has inspired our survival. That doesn't change. And later, when we discussed the Korematsu case, she said, a judge should never rule from fear. A judge should rule from the law and the Constitution. Now, those words give me hope that she will have the courage to defend the liberties of the American people from an overreaching executive or legislative branch. At the same time, she appreciates the deference the judiciary must give to the legislature as it seeks to solve the problems facing the American people. I don't see in her record or in her public statements a burning desire to overturn precedent or to remake constitutional law in the image of her own personal preference, and I certainly don't see any bias of any kind. I was also impressed with her record and statements during the hearing on judicial ethics. Judge Sotomayor seems to understand that the extraordinary power she will wield as a justice must be accompanied by extraordinary care to guard against any apparent conflict of interest. Now, Mr. Chairman, all that being said, I do want to express a note of dissatisfaction, not with you certainly or with my colleagues and not with Judge Sotomayor, but with a nominations process that I think fails to educate the Senate or the public about the views of potential justices on the Supreme Court. In this regard, I completely associate myself with the remarks of my senior senator from Wisconsin, Senator Cole. I've said before that I do not understand why the only person who cannot express an opinion on virtually anything the Supreme Court has done in recent years is the person from whom the American public most needs to hear. It makes no sense to me that the current justices can hear future cases, notwithstanding the fact that we know their views on a legal issue because they wrote or joined an opinion in a previous case that raised a similar issue. But nominees for the court can refuse to tell us what they think about that previous case under the theory that doing so would compromise their independence or their ability to keep an open mind in a future case. I remain unconvinced that the dodge that all nominees now use, I can't answer that question because the issue might come before me on the court, is justified. These hearings have become little more than theater, where senators try to ask clever questions and nominees try to come up with clever ways to respond without answering. This problem certainly did not start with these hearings or this nominee, but perhaps it is inevitable. The chances of the Senate rejecting a nominee who adopts this strategy are very remote based on the recent history of nominations. Nonetheless, I do not think it makes for meaningful advice and consent. So I cannot say that I learned everything about Judge Sonia Sotomayor that I would have liked to have learned. What I did learn about her makes me believe that she will serve with distinction on the court and that I should vote in favor of her confirmation. Thank you, Mr. Chairman.
Thank you very much, Senator Feingold, and thank you, as the others, for the kind personal comments. Senator Kyle, who is the deputy Republican leader, told me that his duties required to be elsewhere, asked consent that he have a statement he wants placed in the record, which, of course, we will. Senator Sessions has his proxy and be able to vote when that time comes. So next is Senator Graham.
Thank you, Mr. Chairman. One, I'd like to add my compliments to you and Senator Sessions for conducting the hearings with whatever shortcomings they may have in terms of finding out about the nominee. I think you did a good job of giving us a chance to ask, and Senator Sessions did a very good job, I think, being part of the loyal opposition. I come to this a little bit differently, and you can tell it in my vote. I'm going to vote for the nominee. And I cannot disassociate myself, being a second-term senator, from what almost happened 3 or 4 years ago. I really enjoy politics. It's been a great honor to represent the people of South Carolina and to be able to have a say about things that matter in the country in a political forum. I enjoyed traveling all around the country trying to help Senator McCain. I failed in that endeavor. Everybody has, they don't feel good about this or that. I didn't feel good about the election, but we lost. I feel good about the country. I feel really good about the American people. And quite frankly, I feel good about Judge Sotomayor. What I'm trying to do with my vote is to recognize that we came perilously close to damaging an institution, the Judiciary, that has held this country together in difficult times. The courts have been all over the place like the American people have been all over the place. Sometimes they have let our ideals down in some of their decisions. But more times than not, the courts were a little bit ahead of the public or politicians on some very important concepts as to who we are. And the filibusters that were going on a few years ago were historic in nature. And I think if carried out and keep repeating themselves, will over time drive good men and women away from wanting to become judges. We ask for the scrutiny that we have as politicians, at the ads we run against each other and all the things that we say about each other. We have a chance to respond. But to be a judge is different. You know, the theory Senator Sessions espouses is true. The law should be a quiet place where even the most unpopular can have a shot. No way could you win in the election, but you might win in court, because there's something a little bit bigger going on in that courtroom than 50 plus 1. So this quiet place we call the law really concerns me, that we're about to change it and make it just an extension of politics in another form. So that's why I'm happy with this hearing. There were no filibusters. And to my colleagues who voted no, I understand. I completely understand. To my colleagues who voted for Justice Roberts, I'm better understanding what you went through. Leahy, Feingold, Cole. You decided to vote for a man you would not have chosen. I am deciding to vote for a woman that I would not have chosen. And as the hearings went on, it got easier, not harder for me. Because all of us seem to have abandoned the Senator Obama test, which would be good for the judiciary in the country. I can no more understand her heart than she can understand mine. And this empathy idea makes us all kind of Dr. Phil's. I feel uncomfortable doing that. I really do. So I base my vote on qualifications. And I came away after the hearing believing that she was well qualified, that the American Bar Association gave her the highest rating anyone could receive, and that meant a lot to me in Alito and Roberts, and it means to me a lot to me now. That she was competent, not just qualified. And it's not me saying that, it's what everybody who's worked with her has said. And she's of good character. So when I rejected the empathy heart standard and went back to what we used to do around here, I found that she was extremely well qualified, 17 years on the bench, 12 years as a Circuit Court of Appeals judge, left of center but certainly within the mainstream. And as to my good friend Senator Grassley, she can be no worse than Souter from our point of view. So there is not going to be a major shift in the balance of power here. But what she will do as a judge, I think, will be based on what she thinks is right, and that's not me saying that or hoping that. That's based on a 12-year record where I haven't seen this activism that we all dread and should reject. And there's another story here. The speeches. the speeches did bug the hell out of me. Not because I disagree with what she was saying. She was a judge at the time she was giving the speeches. And she embraced some concepts that just really were unnerving. But you know what? How many of my speeches would unnerve people on the other side? Probably almost all of them. The speeches had to be put in context of her judicial record. And I do not want to set a standard here, Mr. Chairman, where people aspiring to be a judge will never have a thought, never take on an unpopular cause. The client she represented, I wouldn't have represented that side. I would have been on the other side. But that's okay. And I hope our Democratic colleagues will remember that if a conservative Republican gets back in the White House. It is okay to advocate a position that is different than we would advocate ourselves, because good lawyering is required for a good country. And you want to reward good lawyers when you find them, whether you agree with them or not. So I took the speeches and her advocacy role, and I put it up against her record, and I leave believing that she is well qualified, of good character, and her record over a long period of time is within the mainstream. And the last thing I would like to talk about is not the reason to vote for her or against her, but it is something to acknowledge. We're 200 and something years old as a nation. This is the first Latino woman in the history of the United States to be selected for the Supreme Court. Now that is a big deal. I would not have chosen her, but I understand why President Obama did. I gladly give her my vote because I think she meets the qualifications test that was used in Scalia and Ginsburg. And if she, by being on the court, will inspire young women, particularly Latino women, to seek a career in the law, that would be a good thing. And I believe she will. I wish her well. America has changed for the better with her selection. Thank you, Mr. Chairman.
Thank you, Senator Graham and Senator Schumer.
Thank you, and I want to add my compliments to you, Mr. Chairman, for the judicious way you've conducted these hearings, and I want to say to Senator Sessions, I thought his questions were sharp but fair, and to all of my colleagues that way. I also want to thank Senator Graham for that moving and important speech that he just gave in favor of her nomination. Mr. Chairman, and one final thing, I'm sorry to be coming and going here. We have the Democratic meeting of the Finance Committee to try and tie things down, so I apologize to my colleagues for that. Mr. Chairman, I'm enormously proud to be able to cast my vote today in favor of the confirmation of Judge Sonia Sotomayor. This is a historic day for America. Americans are familiar with the inspiring story that brought Judge Sotomayor from a Bronx housing project through a prestigious legal education and now to a nomination to the highest court in the land. It is a great American story. It will inspire Americans everywhere, Americans of all races and creeds and colors, to reach further and aim higher. And for that, the country is already better off. But Judge Sotomayor is a gifted jurist and dedicated public servant, not just an inspiring story. She's a judge with a 17-year record on the bench, more than 380 opinions on the appellate court alone. And yet, the words that she was asked about most often during the hearings were these three, quote, wise Latina woman. To take a 17-year judicial career and sum it up in 3 words is unfair. It's unfair to Judge Sotomayor. It's unfair to the Supreme Court. It's unfair to the American people. My colleagues did ask about a handful of cases, the New Haven firefighters case, the Second Amendment case, but they were unable to prove anything other than what we knew before the hearings. She follows precedent. In her courtroom, rule of law comes first. Judge Sotomayor's opinions speak much more clearly and loudly than snippets of speeches. Her speeches, as she said, were to inspire and motivate.
Her opinions are to instruct and guide. As Chief Justice Marshall said, quote, to say what the law is, unquote. And when we have so many opinions to review, it is troubling that colleagues seem to be looking for reasons outside of her record to try and posit that she is outside of the mainstream. Of course, even with such a large trove of opinions to examine, hearings do matter. My colleagues on both sides of the aisle were entitled to ask their questions. I was pleased to see that even the most difficult questions were asked and answered respectfully. But Judge Sotomayor's answers only emphasize what is abundantly clear from her lengthy record on the bench. She comes to the bench without arrogance and without an agenda. I have 3 tests for evaluating judicial nominees: excellence, moderation, and diversity. Judge Sotomayor passes all 3 with flying colors. No one can seriously doubt her legal excellence, and I don't think anyone here does. On moderation, I have a hard time understanding how anyone can conclude that she is anything but moderate. In cases ranging from business to criminal law to immigration, she's squarely within the mainstream. In her 17 years on the bench, she has not produced even a stray thought that could be viewed as way outside the mainstream. Finally, the diversity she'll bring to the bench is not just cosmetic. It arises not only from her race and gender, but also from her working-class upbringing and her unique experiences, just as it did for other Supreme Court nominees, such as Justices Alito and Thomas, who spoke movingly of their own backgrounds. If my colleagues cannot support a moderate pick like Judge Sotomayor, it simply suggests they will never support anyone nominated to the Supreme Court by President Obama. She is thoughtful, she is distinguished, she is moderate. Elections do matter. To think that the President would nominate someone who mirrors the beliefs of an extreme conservative, and that is the only person who some of my colleagues could vote for, is perplexing. So, Mr. Chairman, the message from Judge Sotomayor's record comes through loud and clear. It's a message of supreme intelligence and moderation. There is no reason to look further than that, and that is why, among other reasons, I am so proud to vote for her today.
Thank you very much, Senator Schumer, and thank you for introducing her for the committee. Senator Cornyn.
Thank you, Mr. Chairman. I want to thank my colleagues, and as others have thanked the chairman and the ranking member for the manner in which these hearings were conducted. Judge Sotomayor herself acknowledged that she could not have received a fairer treatment before the committee, and it's my hope that will set the tones for hearings in the future, that perhaps somehow we have established a new standard of fairness that will guide both Democrats and Republicans as we consider future nominees from the bench. Last week I made clear my intention to vote no on the confirmation of Judge Sotomayor to the United States Supreme Court, and I will do so for several reasons. First of all, Judge Sotomayor's record as a judge on the District Court and Court of Appeals is generally in the mainstream. Some of her decisions demonstrated the kind of result-oriented decision-making, one that suggests perhaps a liberal judicial activism that has too often steered the court in the wrong direction over the last years. These decisions relate to the Second Amendment, an important provision of the Bill of Rights, not a trivial matter. I think we would all agree. The Takings Clause of the Fifth Amendment, the right to private property rights, and the right to just compensation, and the assurance that private property will not be taken for anything by the government other than for public use. And then, of course, there is the troubling New Haven firefighters case that others have spoken about. And it's not just the decision the judge made without substantial evidence of disparate impact liability. It's also the manner in which almost dismissively, the judge refused to give what I believe a fair consideration of the firefighters' claims in a way that I would hope every judge, every federal judge would. Second, many of Judge Sotomayor's public statements about judging include very radical ideas on the role of a judge in our society. Some have said we can't consider those, but to consider only her judicial record and not consider other statements she has made about how judges should perform in office, I think, is an incomplete picture. She has said there is no neutrality in the law. She has said that legal uncertainty is a good thing because it allows judges to change the law and to make policy. She said that foreign law can get the, quote, creative juices flowing, close quote, as judges interpret the United States Constitution, and that ethnicity and gender can and even should have an impact on a judge's decision-making. Now, I would concede that those are hard to square with her statement that her sole standard as a judge is fidelity to the law. But that, I think, demonstrates the conundrum with which many of us are left. This committee gave Judge Sotomayor the opportunity to explain the reasoning behind some of her most controversial decisions, as well as some of her public statements about judging, and to allow her to put that into an appropriate context. But I don't believe she cleared up the confusion over what kind of justice she would be, because I have no confidence which Judge Sonia Sotomayor we will see on the Supreme Court. I will vote against the nomination. The stakes are simply too high to vote to confirm someone who could redefine the law of the land from the bench. I know many senators take the position that Judge Sotomayor will not address legal questions from a liberal, activist perspective, and I hope they're right. I also hope that her testimony before this committee represents a teaching moment, a moment that defines our consensus on what the proper role of a judge should be. In the past, we seem to have had very heated disagreements about judicial philosophy and judicial activism. We debated original understanding versus an evolving constitution. Yet I think a remarkable thing happened during the course of Judge Sotomayor's confirmation hearings. We seem to have agreed that judges should interpret the law, not make the law. We seem to agree that judges should rely upon the original intent of the framers when interpreting the Constitution, not on foreign law or international law. We seem to agree that judges should apply the law faithfully and not move the law in one direction or another based on their own policy preferences. And yes, we agree that judges should be impartial and not pick winners and losers based on some subjective empathy standard or whatever is in the judge's heart. Mr. Chairman, I think we've come remarkably close to embracing the Hamiltonian standard in Federalist 78, where he called the judiciary the least dangerous branch, having neither force nor will, merely judgment. If that is in fact the case, then I think we will have accomplished much in the course of this confirmation process. I, for one, would find that consensus encouraging. We've defined where the judicial mainstream is, and we've made clear that radical views on judging have no place on the federal bench. And we've set expectations, I believe, for future nominees. Thank you, Mr. Chairman.
Thank you, Senator Cornyn and Senator Durbin.
Thank you very much, Mr. Chairman. A few weeks ago, my colleague and friend, Senator Al Franken, came to my office the day after he was sworn in. We talked about his new role in the United States Senate and some of the challenges he'd already faced, and he talked about the first 3 votes that he cast as a United States Senator. I tried to remember the first 3 votes I cast as a United States Senator. I couldn't. After you've served in the House and the Senate for a period of time, you come to realize that you have to be reminded on some of these votes. But there are some votes that you will remember for a lifetime. One of them is a vote on whether our nation should go to war. That is a type of vote that you'll always remember. It's one of the most important decisions we make, and so is this decision. because we are asked to judge whether a man or woman should be appointed for life to serve on the United States Supreme Court. The court that defines our personal rights to privacy, decides the restrictions that can be placed on the most personal aspects of our lives and our freedom. The Supreme Court decides the rights of workers, consumers, immigrants, and discrimination victims. The 9 justices decide whether Congress has the authority to pass laws to protect our civil rights and our environment. They decide what checks will govern the executive branch in war and in peace. Because these issues are so important, we obviously need justices with intelligence, knowledge of the law, the proper judicial temperament, and a commitment to impartial justice. In the 220-year history of the United States, 110 Supreme Court justices have served under our Constitution. 106 of them have been white males. We have had 2 women justices and 2 African Americans. That's why this is such an historic moment, because President Obama's nomination of Sonia Sotomayor is indeed groundbreaking. In life and in our nation, if you want to be the first, you have to be the best. Sonia Sotomayor's resume, I think, meets that standard. When you take a look at her life, her splendid life story, you may not be able to see it as some of us have seen it from this side of the table. We sat there during the course of this hearing as Judge Sotomayor told her life story, and I spent more time watching her mother than watching her. Her mom, who nodded as Judge Sotomayor told that story, of growing up in public housing, of losing her father when she was 9 years old, of struggling to succeed against adversity and illness, of reaching the pinnacle of success and academic achievement at Princeton and the same at Yale Law School, of serving as a prosecutor, and going on to be selected by President George Herbert Walker Bush to serve in the federal judiciary, and then promoted by President Bill Clinton, a rare occurrence that someone receives bipartisan support for their judicial service, which she had. And each time as those facts were recounted, I watched her mother nodding, recalling what her daughter had achieved. What a great story it is for America. And what a great story it is that President Obama would give us a chance to consider Judge Sotomayor to serve as the first Hispanic woman on the United States Supreme Court. But for many who oppose Judge Sotomayor, her life achievements and her judicial record are just not good enough. After poring over 3,000 court decisions and hundreds of her speeches, Judge Sotomayor's critics focused their opposition primarily, not exclusively, but primarily on one case, the Ricci case, and on one sentence from one speech. I hope someone was keeping track of how many times those 3 words, wise Latina woman, were quoted during the course of this hearing. Senator after senator asked her, what did you really, really, really mean with those 3 words? Over and over again. We are senators who live in a world of decisions and votes every day, and we understand when our decisions and votes are questioned and challenged, often in an unfair fashion. If we vote in a way that's controversial, we ask that people be fair and judge us on our life's work, not on a single vote. It's a standard we ask for ourselves, but obviously for some, it's not a standard they would give Judge Sotomayor when it comes to her decisions. We also live in a world as senators of revised and extended remarks, jokes that flop, and verbal gaffes. Many want to condemn Sotomayor for her wise Latina remark that she conceded was a rhetorical flourish that fell flat. But I listened carefully to what she had to say, and I noted at the end of the day that she had received the highest possible rating from the American Bar Association, which interviewed 500 judges and practitioners in order to assess her integrity, competence, and temperament, the highest possible rating. In my state of Illinois, the conservative Chicago Tribune said this of her testimony. In 4 days of testimony, under often intense questioning, Judge Sotomayor handled herself with grace and patience. She displayed a thorough knowledge of case law and appreciation of her critics' concern. The result was to reinforce a strong case that she will make a good Supreme Court justice and deserves Senate approval. A lot has been said about the issue of empathy and this question of the wise Latina woman. I pointed out when I asked Judge Sotomayor that the wise Latina speech contains a line that her critics didn't often quote. In that line, Judge Sotomayor noted in the same speech that it was 9 white male justices on the Supreme Court who unanimously handed down Brown versus Board of Education and other cases upholding sex and race discrimination. Judge Sotomayor made it clear at her hearing that she believes that no single race or gender has a monopoly on good judgment. For some of my colleagues, Sonia Sotomayor's statements under oath are not good enough. I would hope that senators would be wise enough themselves to look at Judge Sotomayor's long record on the bench and not on one line in one speech taken out of context. Now let's be honest. A great deal of this debate is about diversity. Why do we seek diversity when it comes to appointments to the federal bench? First, we are a diverse nation. Second, we want every American to believe they have an equal opportunity to succeed and lead. But we also want every American, black, white, and brown, male and female, to know that our system of government is fair. We want all Americans to look at our Congress and our courts and feel there are leaders who can identify with the diversity of life experience in this great, diverse nation. Does anyone really believe that there is a clear, objective answer in every case that comes before the Supreme Court? The precedent is so clear and the law is so clear? Well, if they do, try to explain why 1/3 of all the rulings of that court in the past term were decided by a 5-4 vote. Does anyone really believe the Supreme Court's recent strip search case would have come out the same way if Justice Ginsburg, the only woman on the court at this moment, hadn't helped her 8 male colleagues understand what it's like for a 13-year-old girl to be treated in such a humiliating fashion? Does anyone really believe that women judges haven't helped their male colleagues understand the realities of sex discrimination and sex harassment in the workplace? Study after study has shown that men and women on the bench sometimes rule differently in discrimination cases. This doesn't mean their rulings are based on personal bias. It simply acknowledges that Americans see the world through a prism of varied experiences and perspectives. Our Supreme Court justices should possess an equally rich and wide field of vision as they interpret the facts in the law. Criticizing Judge Sotomayor for recognizing this reality is unfair. Mr. Chairman, something's happened since we concluded the hearings, which is unusual. A major lobby group in Washington, D.C., the National Rifle Association, has for the first time notified their members and colleagues that this is going to be on the scorecard. The gun lobby, the National Rifle Association, has come out in opposition to Judge Sotomayor. I believe it's the first time that they've ever taken a position on a Supreme Court justice. I listened to her testimony on the Maloney case. Most of the criticism of her on this issue has focused on that case. But in that case, she came to the exact same conclusion as a 3-judge panel of the 7th Circuit, based in my home state of Illinois, which featured 2 of our most conservative icons on the federal bench, Frank Easterbrook and Richard Posner. They concluded that only the Supreme Court, not appellate courts, can overrule century-old Supreme Court precedents on whether the Second Amendment right to bear arms applies to the states. I realize the National Rifle Association and their Senate allies don't like that ruling. They apparently wanted Judge Sotomayor to do what the 9th Circuit did and overrule Supreme Court precedent. But in the Maloney case, Judge Sotomayor did what an appellate court should do, and she followed the law. The Sotomayor nomination is the 3rd Supreme Court nomination I voted on in 12.5 years I've served in the Senate. Because the stakes are so high, I believe Supreme Court nominees carry the burden of proof when they come before the Senate. They must prove they are worthy of a lifetime appointment to the highest court in the land. Judge Sotomayor has met and exceeded this burden. America will be well served when Judge Sotomayor becomes Justice Sotomayor, and I enthusiastically support her nomination.
Thank you, Senator Durbin. Senator Coburn.
Thank you, Mr. Chairman.
trying to figure out how to couch my words since I've just been condemned that because the basis of my vote might not be on something that Senator Durbin would think would be appropriate. I would mention that the Ninth Circuit ruled the opposite of your circuit, Senator Durbin, on the Second Amendment. And I'd also note for the record that the very person on our side that questioned Judge Sotomayor on her wise Latina comment was the very member that's going to be voting for her. He had more questions of her than anyone on our side on that regard. So I think it's somewhat unfair to characterize us with a broad brush. I'm proud that President Obama has nominated such a distinguished woman. I identify with Senator Cole and Senator Feingold. The great disturbance that we have that we can't get real answers in these hearings. I believe what we say as judges truly does come from our heart. Most of her speeches were before teaching moments through either students or legal societies or others. And I believe she believed in what she was saying. And I also believe she has great credit that a lot of times she's not allowed her personal beliefs to influence her judgments. But the dissonance that I came away with is what you believe, you ought to stand up for and then defend your record to be able to say, I can still be a great judge. But on the two questions when she was asked, one about foreign law, and her outside, very critical, very negative statements about Justices Scalia and Thomas, and then to walk away from that saying that she didn't say that is just flat not accurate. And then also to finally come to a point recognizing the Supreme Court Justice's job is not to think about what the rest of the world thinks about us. Their job is to interpret the Constitution and to use the statutes and our Constitution and the facts. I think she is one impressive individual. And I thoroughly enjoyed her. I like her a lot. But that's not good enough for me. And it doesn't have anything to do with other than whether or not I believe with confidence that she has an understanding of the Second Amendment, the Fifth Amendment, the 14th Amendment, and the Fourth Amendment. And although I will have a complete written statement for the record, she is going to be on the court for life. Stare decisis doesn't count because they get to change it. They get to change it. And we all know the major instances and shifts in this country that have taken about when they have done so. So I go back to what Senator Cole said when we started out. We need to change the rules for the hearings. We need to let judges really let us know what they think, but also sell us on the fact that they, in fact, are impartial dividers of the truth, regardless of what they think. That's the characteristic of a great judge, is that their personal thoughts don't enter, that they take the facts, all of the facts, and decide what the ruling will be on the basis of that and that only. To have something other than that on the Supreme Court, which I agree, from both sides of the aisle, has happened, hurts us in the long run. So I align myself with the comments of Senators Feingold and Cole in hoping that future hearings, although I think it was a remarkable hearing, the chairman did a great job, and I think the American people got to see a great deal of this very fine woman. I regret that I cannot vote for her. And I can't vote for her not because she's a Latina woman, and I can't vote for her because she has said all those things. I can't vote for her because she wouldn't defend what she said and stand up and say, I really believe this, but I can still be a great judge anyway, because I will never let that interfere with my judgment. And that's what I was looking for, and it wasn't there. With that, I yield.
Senator Cardin.
Well, Mr. Chairman, first, let me observe this is my first opportunity to participate in the confirmation process of a Supreme Court justice. And I just want to thank you, Mr. Chairman, Chairman Leahy, for the manner in which he has conducted this hearing. I want to thank Senator Sessions for the fairness in which he worked with our chairman so that each one of us would have the opportunity to ask as many questions as we want to get all the information. I might point out, I've been told by staff that there were 17 questions asked on a wise Latino. So we not only compliment Judge Sotomayor for her patience, but I want to compliment the chairman and ranking member for their patience in allowing each of us to pursue the information we thought that was relevant in evaluating Judge Sotomayor's qualifications to serve on the Supreme Court of the United States. Now, I believe Judge Sotomayor's background and her professional accomplishments will add strength, balance, and leadership to the Supreme Court. Her personal story that we've heard about being part of an immigrant family from Puerto Rico, the fact that she received a scholarship to be able to attend college, it is an inspirational story about success in our country. We know her professional background as a prosecutor, a trial judge, and appellate judge, having more judicial experience than any nominee for the Supreme Court in 100 years. Her command of legal precedent and her ability to challenge attorneys in their legal arguments will bode well to reach the right decisions in the Supreme Court of the United States. Her leadership ability in forging consensus among the judges in the Second Circuit will be a talent that I think will be very helpful in the Supreme Court of the United States. She is mainstream in her judicial decisions and opinions, with a correct sense of the role of a judge to decide a case based on sound legal precedent and the facts of the case, giving due deference to the Congress of the United States. She has a record of understanding the Constitution and the Bill of Rights as a timeless document able to protect individual rights against the abuses of power, applying these protections to contemporary challenges. She follows precedent to advance individual rights. You get confidence that she will reach the right decisions for the right reasons, not only based upon her response to our questions, and she answered every one of our questions, but in reviewing her decisions and her opinions. That's where I think we should spend most of our attention. So let me just mention a few. I have confidence that she will follow the protections that Congress has passed in protecting our environment. The Riverkeeper case gives me that confidence. I have confidence that she understands the importance of freedom of speech in the decision that she reached in Pappas versus Giuliani. Now, the speech there was repugnant, that all of us find repugnant, but she understands the importance of the constitutional protections. I have confidence that she will pursue freedom of religion. The Ford versus McGinnis case, where she protected the rights of religious freedom for a minority whose religious practice is not as well known by the majority in our population. She protected the civil rights of Americans and the equal opportunity and racial justice. We have the Gantt case, where she did that in our schools, protecting the rights of an African American. The Boykin case, where she protected the rights in housing matters, which are very important today. We know that there is predatory practices against minorities in our community. I have confidence that she understands those concerns. I was particularly impressed by her commitment on voting rights. In response to my question, acknowledging that this is a fundamental right. She showed in the Hayden case a deference for following Congress and protecting voting rights. That's going to be particularly important as we look at the Voting Rights Act. And she has shown an understanding of privacy rights. Now here we don't have court cases that we can look at, but her response to our questions and her background give me confidence that she will respect legal precedent and advance privacy in the 21st century. As I said in the beginning, Mr. Chairman, this is my first opportunity to participate in the confirmation process of a Supreme Court nominee. 3 years ago, I told the people of Maryland how I would judge judicial nominations by their experience, their temperament, and their understanding for the Constitution of the United States. For all these reasons, I will vote for the confirmation of Judge Sotomayor to be Justice Sotomayor.
Thank you very much, Senator Cardin. I appreciate that. Senator Whitehouse.
Thank you, Chairman, and thank you for your wise and fair leadership of these confirmation proceedings. I also thank the ranking member for his fairness and courtesy throughout the proceedings. I will be proud to vote in support of Judge Sotomayor's confirmation to the United States Supreme Court. I appreciate, as I know the Chairman and others do, her background as a prosecutor. And I believe her non-controversial 17-year record as a federal judge makes clear that she's dedicated to the rule of law, has a proper judicial temperament, and gives every party before her a fair hearing. I also believe the unequivocal pledge that Judge Sotomayor gave me, that she will respect the role of Congress as representatives of the American people, that she will decide cases based on the law and the facts, that she will not prejudge any case but listen to every party that comes before her, and that she will respect precedent and limit herself to the issues that the court must decide. In short, that she will use the broad discretion of a Supreme Court justice wisely. She promised that, and I take her at her word. Mr. Chairman, I think we are witness here to an effort to define justice in America in alignment with a particular point of view. My colleagues are entitled to their point of view. They're entitled to their point of view about guns. They're entitled to their point of view about property rights. They're entitled to their point of view about other issues. What I resist is any effort to define that point of view as a judicial norm against which any other point of view is to be seen as an aberration, as biases and prejudices, to use one quotation. In this case, I further believe that their definition of justice in America, their definition, is just plain wrong, both as history and as justice. In particular, I do not wish to force as the new judicial norm the sort of judges who, to paraphrase a recent article on the Supreme Court, in every major case vote for the corporation against the individual, for the government against the criminal defendant, and for the executive branch against the legislature. I do not wish judges without empathy who will ignore the long and proud history of the courtroom as the last stand for many beleaguered Americans, where they can get fearless justice even when all of the forces of politics, of proper opinion, and of corporate power may be arrayed against them, with judges willing to provide that fearless justice even if it completely upsets the status quo. I would add that I find no fault in judges who won't, as the price of entry to the court, commit to expanding our newly minted individual right to own guns, a right that no Supreme Court for 220 years had previously noticed, and that was created in a 5-4 decision by a divided court. So I will, with pride, support Justice Sotomayor's nomination. It is an honor to serve on this committee and to vote for such a talented and exceptional person. We all realize that Judge Sotomayor will be an historic justice, but I think we can also expect that, most important, she will be an excellent justice. Thank you, Mr. Chairman.
Well, thank you very much, Senator Whitehouse. I appreciate the comments. And Senator Kaufman. No, Senator Klobuchar. I apologize.
That's fine.
Of course, Senator Klobuchar, former prosecutor before she came here, as was Senator Whitehouse. Please go ahead.
Thank you very much, Mr. Chairman, and I wanted to thank you and the ranking member for holding such a civil and dignified hearing. I had a few people say that it got boring at times, and maybe that is a tribute to the fact that it was a civil and dignified hearing. Like many of my colleagues, I have been so impressed by Judge Sotomayor. Like Senator Durbin, I most remember her mother sitting behind her, that mother who, when the father died at age 9, Judge Sotomayor was raised by that mother who had hardly any money, a nurse, saved all her money just to buy their family Encyclopedia Britannicas. And when you watch that family and her brother, it reminded you that Judge Sotomayor knows the law and she knows the Constitution, but she also knows America. One experience of hers in particular resonates with me, and that is that immediately after graduating from law school that she became a prosecutor. And I believe that that experience and my discussions with her will forever shape how she views the law. As a prosecutor, after you've interacted with victims of crime, after you've seen the damage that crime does to individual families and to communities, you know that the law is not just an abstract subject. It's not just a book in your basement. You see how the law has a real impact on the lives of real people. Judge Sotomayor's experience as a prosecutor tells me that she meets one of my criteria for a Supreme Court justice. I'm looking for someone who deeply appreciates the power and the impact that laws in the criminal justice system have on real people's lives. In addition to her work as a prosecutor, we learned a lot about Judge Sotomayor's long record as a judge. She came into this as a nominee with more federal trial judge, federal court experience than any nominee in 100 years. Now, I believe that my colleagues on this committee are entitled to oppose Judge Sotomayor's nomination if they wish. But I do get concerned when people return again and again and again to a quote in some speeches. And I was so pleased that Senator Graham, my colleague from South Carolina, put those speeches in some context. You have to look at her whole experience. You have to look at her 17 years as a judge. You have to look at the fairness that she brings to this job. In the words of Senator Moynihan, you are entitled to your own opinion, but you are not entitled to your own facts. And in this case, the facts are her judicial record. The nominee was repeatedly questioned about whether she would let bias or prejudice infect her judging. She was questioned for hours. She was questioned for days. But again, the facts don't support this kind of bias. In race discrimination cases, for example, Judge Sotomayor voted against plaintiffs 81% of the time. Her decisions are supported by precedent. When she served on panels with Republican-appointed judges, she agreed with them 95% of the time. I appreciated Senator Durbin's discussion of the Maloney cases. I agree with the Heller case, but the Heller case specifically left open the question that Judge Sotomayor was confronted with in the Maloney case. And in fact, the decision that she and her colleagues came to was the same decision that three-judge panel on the Seventh Circuit came to, which included Judge Easterbrook and Judge Posner, who were professors at University of Chicago Law School when I was there, and I can tell you they are not exactly rabid liberals. And I just wonder if people would be using that same case against them if they were before us today as was used against Judge Sotomayor. Judge Sotomayor also handed out longer jail sentences than her colleagues as a district court judge. She sentenced white-collar criminals to at least 6 months in prison 48% of the time, whereas her other colleagues did so 34% of the time. And in drug cases, 85.5% of convicted drug offenders received a prison sentence of at least 6 months from Judge Sotomayor, compared with only 79% in her colleagues' cases. The nominee was questioned repeatedly about issues ranging from the death penalty to use of foreign law, even though she rejected a defendant's challenge to the death penalty in the one death penalty case that she considered as a district court judge, and even though she has never cited foreign law to help her interpret a provision of the United States Constitution. Again, the facts are in her judicial record. She received a unanimous positive rating from the ABA. Why? Because she is a thorough judge who bases her decisions on the facts. She was supported by prosecutors across the country and by police across the country. Why? Because they looked at her record and they trusted her decision-making. I think just about everything in the nominee's professional record is a fair game to consider, and that's why I believe that this was a civil and dignified hearing. But that said, when people focus on a few items in a few speeches, you have to wonder, do a few statements that someone made in an entire career trump 17 years of modest, reasoned, careful judicial decision-making? There is one other point that I wanted to address that hasn't been addressed, and that's because it irritated me, and that was the issues that were raised about the stories and comments, mostly anonymous, that questioned Judge Sotomayor's judicial temperament. According to one news story about this topic, Judge Sotomayor developed a reputation for asking tough questions at oral arguments and for being sometimes brisk and curt with lawyers who were not prepared to answer them. Well, where I come from, asking tough questions and having very little patience for unprepared lawyers is the very definition of being a judge. As a lawyer, you owe it to the bench and to your clients to be as well prepared as you possibly can. When Justice Ginsburg was asked about these anonymous comments regarding Judge Sotomayor's temperament recently, she rhetorically asked, "Has anybody watched Scalia or Breyer up on the bench?" Surely we've come to a point in this country where we can confirm as many gruff, to-the-point female judges as we've confirmed gruff, to-the-point male judges. In short, Mr. Chairman, I am proud to support Judge Sotomayor's nomination, and I believe she will make an excellent Supreme Court justice. She knows the law, and she knows the Constitution, but she knows America, too. Thank you very much.
Thank you very much, Senator Klobuchar. And next, Senator Kaufman.
Mr. Chairman, I'd like to begin by others have commending you and the ranking member on running an excellent hearing, a fair hearing. Everyone had a chance to speak. Everyone had a chance to ask questions, and it was just very, very well run.
Thank you.
Judge Sotomayor is an outstanding nominee. She has a superior intellect, broad experience, superb judgment, and unquestioned integrity. She would be a terrific choice at any time. But given our current economic crisis and the likely role of the court in reviewing legislative responses to that crisis, I submit that she's the ideal nominee at this time. One thing we've learned over the last 2 years is that we must reform our financial markets. Judge Sotomayor's extensive experience as a commercial litigator, business lawyer, judge in business cases, and the passion for the law that she has demonstrated throughout her career suggests that she'll be a leader on the court on business and regulatory issues at a time when such leadership is essential. As I said, she'll be an excellent nominee, and especially at this time. Mr. Chairman, I'd also like to have my statement of July 24th I made on